Well, good day and welcome to the Employment Law Show. Good to have you with us for the next 30 minutes. You will learn lots. That's about the guarantee we give you every week. John Scholes here, an employment lawyer, Lior Samfiru from Samfiru Tumarkin LLP, the most positively reviewed law firm in this wonderful country of ours. We tell you right off the top every week, always reach out to Lior with any questions. That number's simple, 1-855-821-5900. You prefer the email route, that is help@employmentlawyer.ca, and an all-encompassing website that'll teach you tons, give you contact information and access to what we call the Severance Calculator. Millions, and I mean literally millions of Canadians have used it and discovered what severance really should be. That is all found at pocketemploymentlawyer.ca. We'll dip into that a little later in the show. As well, our main topic, 5 common employment law terms. There's 1,005, but we narrowed it down to 5 for the purpose of this show. That's coming up in just a bit, Lior, but we always kick off the show, get warmed up with the week that was. Pal, what do you got going on?
Yeah, good, John. Great to be here, of course. Great to talk to our viewers about employment law. To have this opportunity to sit here at this desk, to talk to you and educate you and give you some tools, it's so important to me, and I'm very happy that I have this opportunity. You'll learn about your rights. You'll learn what to do if your employer says something or does something that they're not supposed to. You'll learn how to deal with the situation where you lost your job and you're trying to understand what you're owed or if the termination was even legal. You'll learn what to do if your job changes, your hours, your compensation. If you're being mistreated in your job, what to do. What does the law say? We cover these topics and many others every single week, so you're in the right place if you care about your legal rights. And of course, on the show, I can tell you information. I can give you some explanation. What I can't do is actually talk to you. To do that, you need to reach out to me in the office. You can call or email. We'll give you that contact information throughout the show so that we can have that chat and private discussion about your specific situation. But of course, always like to start off with the situation that came across my desk, because you may be in that situation either now or in the future, or someone that you know may be. And so it's important that you understand what the law says. So John, I spoke with a lady who about 3 years ago, the business that she had worked in was sold. Small retail company, and the business was sold. She had been with the same retailer for over 12 years. So unfortunately, business is not doing too great. So the company, this is a new owner now, decided to sell the business, to close the business and let her go. So she'd been with this new employer for 3 years. So company says, we know we have to pay you severance. We've done our research and we're going to pay you 3 weeks pay. Of course, it didn't sound right for this lady. She's now been with this retail store for about 15 years, 12 years previously, but 3 years with a new company. So she called me, thankfully, and she wanted to understand her rights. So here's what her rights are. When the business was sold, that new company inherited her service. They inherited it. That's what happens. She had 12 years, so on day one with the new owner, she was a 12-year employee. Fast forward now, 3 years later, she's now a 15-year employee. So she has to get paid severance like a 15-year employee. So for her, that's, John, about 18 months of severance. 18 months. Now, she'd only worked there for 3 years. Company says 3 weeks. It's 18 months. Huge amount that she's owed. I'm going to help her get that severance. It's not even complicated, but I wanted to remind all our viewers right now. If you're working for a company, if that company is sold, sale of a business happens, your service gets inherited by the buyer, which means later on, if you lose your job, you're going to have to get severance based on your total years. But a very important thing to remember in this situation is when you do start working with the buyer, don't sign anything. Don't sign an employment agreement that gives up future rights. Your new owner, the new owner of the company may say, yeah, we'll hire you, but we want you to sign a piece of paper, an employment agreement that says we're not recognizing past service. Be very careful with that. If you're ever asked to sign anything like that, before you do, call me. Let's talk about that. But otherwise, yeah, your employer, the new company, the new owner inherits your service.
Yeah, I was just going to ask that actually, that contract saying we're not going to inherit your past service, is that the one workaround that the new buyer has to avoid paying that hefty amount of severance?
That's not a workaround, that's the only workaround. And yes, I'll say this, a smart owner or a smart buyer will have employees sign that. That doesn't mean an employee should sign that. That doesn't mean that an employee should agree to something like that. So if you're starting a new job and you're being handed an employment agreement, be extra careful. Always be careful when you sign an employment agreement, but be that much more careful. Frankly, best advice I'm going to be able to give you, send me a copy. Let me see it, let me read it so that you know what you're agreeing to.
So 2 questions from the employee standpoint. What if she turned around and said, you know what, I don't like this buyer. My spidey sense are going off. I'm not even going to start this job, so I will not continue on with the new buyer. Or if the new buyer inherited her service, but they didn't even have her work the first day. Who pays severance in that case? Buyer, seller, buyer?
So if you're offered a job by a buyer and you never, you don't accept the job for whatever reason, you still get severance by the seller.
Okay.
Now, depending on why you didn't accept the job, you may get your full severance or just part of your severance. If you had a good reason, for example, the job was for less pay or for different hours or different location, you get your full severance. If you didn't have a good reason, you just said, you know what, I don't like this person, I'm going to go find something else, then you're still going to get your severance from the seller, but not your full amount. But bottom line is severance will be paid. So maybe as a good piece of advice is before you actually make a decision as to whether you're going to accept the job with the buyer or not, let's talk so you understand what's at stake, so you understand what you're owed if you accept the job or if you don't accept the job.
EmploymentLawyer.ca, another good website to use anytime. You'll find links to our long-running radio shows pretty much across the country. A province near you will pretty much guaranteed run our radio show weekly. And we talk to a lot of people on air. They call in, they ask questions, they get really quick answers before they move on to Lior, possibly at a later time. But we take some of those phone calls, we play them back here. We like to talk about them. First phone call from one of our radio shows. Let's get to it right now.
My spouse, after 10 years of employment, was laid off and then basically not invited to come back. He has been offered a severance package. During the 10 years, his phone was fully paid for because it was used for work, and he also had a company vehicle.
What kind of a job was your husband doing?
He was in pest control.
How old is your husband?
47.
So this is a good question, a good time to remind everyone that when it comes to your severance, it has to include all components of compensation. So it's not just your base salary. So if you have a company vehicle, that has to be accounted for as part of your severance. If you have a company phone, if you have other entitlements, bonuses, commissions, any other component of your compensation, those have to be included. And what I often see is situations where when a company pays severance, they don't forget about your salary, but they don't account for, they quote unquote forget about those other components. And those can add up very, very quickly. So for this person, yes, he's of course going to be owed his car to be continued or a similar value or use of a phone, or again, to compensate him for a similar value for that use of a phone. But of course, we also want to know how many months of compensation, how many months is he actually owed? Is it 2 months? Is it 24 months? Is it something in between? Well, for that, we're going to go back, of course, and use our severance calculator tool. You can find it yourself. Just grab your smartphone, tablet. It's free and anonymous. Go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. We're going to use that right now for this particular person. Let's see how much severance they're owed after 10 years of employment. You see that they're 47 years of age. Severance, 10 weeks, maybe the company says. Who knows what they're offering? Well, we know what the person is owed. 12 to 14 months. So that's 12 to 14 months of salary, bonus, benefits, car, phone, all components of compensation. That's why you at home should use pocketemploymentlawyer.ca if you lost your job or maybe are just curious to know what you're owed.
This one I find interesting because in this case, it's pest control. So the company car is probably more often than not a pest control truck. So it's going to have raccoon cages in the back, rat traps.
Right.
I mean, it's not like a salesperson who's been given a Lexus, so it's just a car's a car. Does that still qualify as compensation, even though it's a company pest control truck?
So it's a question of whether or not the car is only used for work or is it used for personal use. So if you only use the car for work, to get to work, to customers, to do your pest control work, then no, it does not have to be included as part of severance because you're not going to be doing that work, so you're not going to need the car. But if it's a company that or it's a vehicle that you're treating like your own vehicle, you drive it personally for your family, you take it on the weekends, etc., then there's a value to you. So that's part of your compensation, which means it has to be accounted for as part of your severance as well.
Another website you can use anytime anonymously. It's, in fact, Constructor for you to ask questions any kind. It's called terminationquestions.com. That's how easy it is on your smartphone, tablet, or desktop, terminationquestions.com. We'll get to one from it. Lior says, is it considered a wrongful dismissal if my employer did not provide a valid reason for firing me? I was told I was let go due to financial difficulties, but I recently saw an ad for my position.
I get this exact question or very, very similar versions of it literally every day. Company says, we're letting you go for this reason, and you find out very quickly that that reason is not true. In this case, they saw a posting for their job somewhere. Yeah. So clearly it's not because they're eliminating the position. So we know that this employer may be dishonest, but that's not the question. The question is this employer doing something illegal? The answer, unfortunately, is no. This is not illegal. An employer does not have to give a reason or to give a real reason as to why you were let go. Your employer can let you go for good reason, bad reason, no reason even, as long, this is the key, as long as they pay you your proper severance. So the question for this person is, did he or she receive proper severance? If they did, the employer met their obligation. If they did not, that would be a wrongful dismissal. So no, the fact that the employer lied in and of itself, the employer lied about the reason, does not make this whole situation illegal.
Do you find people get hung up on that they were lied to about the reason they were let go? You got to kind of get them to work past that and concentrate more on the job at hand, which is your severance?
Absolutely, because it's unfair, right?
Yeah.
And
it's insulting, right?
It's insulting. You're immediately thinking that this employer is hiding something from you, and maybe they are. Now, unfortunately, the law, I always say, the law can't make someone a better person. The only thing the law can do is deal in compensation. And the compensation, when it comes to employment, we call severance. So the law can't make your employer be honest if they lied about the reason, but the law can definitely ensure that you get every dollar that you should have.
Our main topic has mentioned 5 common employment law terms. That's coming up after the break, which we'll dip into now and come right back from it. In the meantime, that phone number, always use it, 1-855-821-5900. Email help@employmentlawyer.ca. Lots more on the way. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Employment Law Show. Reach out anytime. You can always do that to Lior and his team. The phone number first, 1-855-821-5900. Email help@employmentlawyer.ca or pocketemploymentlawyer.ca. We'll go over that several times. I keep hammering it home. It's a great website. It was built just for you to educate yourself about employment laws, and you'll have access to the severance pay calculator as well. But main topic, here we go. 5 common employment law terms. Start off with the big one, independent and dependent contractor. What do you think about it?
So a contractor, whether independent or dependent, I'll talk about that distinction in a second, but a contractor is someone that's, well, not an employee, someone that's in business for himself or herself. So a contractor is someone that operates a business, that has various customers and clients. They manage those customers. They manage their expenses because, again, they're running a business. So if you are, in fact, someone that is out there marketing your services, you're getting customers and clients, you're deciding who you work for and who you don't and how much you're going to charge, then yes, you're a contractor. You're not an employee. That's very different from someone that actually has a job, someone that goes to work, does what their boss tells them, finishes the work, goes home, comes back the next day, does the same thing. That person is an employee. The unfortunate thing is that too many times people that are really employees, the law sees them as employees, they're being misclassified. The company they work for calls them a contractor, but they're not. So always ask yourself, are you in business for yourself? If you are in business for yourself, then yeah, you're a contractor. And the reason why we want to get this right is because employees have rights. Minimum wage, vacation pay, holiday pay, severance. A contractor, and certainly an independent contractor, doesn't. So you want to get this right. Now, a dependent contractor is really a contractor that does a lot of work for one particular company. So that company, their biggest client, has some obligations to them. For example, they may have to pay them severance still if they let them go. But we talked about pocketemploymentlawyer.ca. One of the tools there allows you to find out if you yourself, if you're an independent contractor or you are an employee, if you've been misclassified. So check it out for yourself.
Dependent, what's the threshold about? You mentioned that one big client that may have to pay some severance. 60% of your nut, 70%, 80%?
So recently the courts have kind of increased that threshold. So it'd have to be probably about 3/4 of your compensation with one company before you're considered a dependent contractor. And again, if you have, let's say, 5 customers, but there's one really big one where you do the majority of your work with, if that one customer lets you go, they may still have to pay you severance because of the financial hit to you that would happen if, in fact, that relationship came to an end.
Okay, employment law term number 2 is this one. We love this one, wrongful dismissal. That is creating confusion, just me saying it. Wrongful dismissal. What does it mean?
I can see the confusion everywhere.
Right.
So I alluded to the fact earlier that an employer can let an employee go pretty much for any reason. So generally speaking, the reason you were let go, whether it's good or bad reason, is not something that's going to make it a wrongful dismissal. You're not wrongfully dismissed necessarily if the company has a bad reason to let you go. So what is a wrongful dismissal? Well, a wrongful dismissal is simply a situation where you've been let go without your full and proper severance. So yes, believe it or not, a wrongful dismissal has nothing to do with whether the reason is wrong. What makes it a wrongful dismissal is not getting severance. If you get your proper severance, but the company lied to you about your reason, you haven't been wrongfully dismissed. But here's the thing, over 90% of people, when they lose their job, have been wrongfully dismissed because whatever they've been offered for their severance is not what they're owed. It's a lot less than what they're owed. So chances are, if you lost your job, whether it's today or 10 years ago, you've been wrongfully dismissed. So it's all about that severance.
We were talking about 5 common employment law terms. There could be 1,005. We'll do them on a future show, but we've whittled down to 5 big ones that we bring up and talk about all the time. Third one is working notice. Working notice. Working
notice. We're talking about what we call working notice of termination. So we know, I've already said that a company has to pay severance if they let someone go. Well, one of the ways they can provide that severance is actually by not actually paying severance, by giving enough working notice, advance notice of termination that the person loses their job. So I'm going to give you an example. Let's say if you lost your job today, let's say you'd be owed 9 months of severance. Well, one of the ways an employer can give you that 9 months is instead of saying you're gone today, we're going to pay you 9 months severance, is to say you're gone in 9 months. So we're giving you working notice of 9 months, and that's it. Now, as long as the number of months that you got is sufficient, then you're not going to be owed severance at the end of it. Now, what happens very often, though, is the amount of notice that the company gives is not sufficient, is not enough, which means they have to make up the difference by way of severance. But this concept of working notice is important because it does count towards your severance.
Employment law term number 4, it's basically what this whole show is based on, that is common law. Common law, right?
Right. So again, when it comes to your entitlements if you lose your job, your sources of entitlements come from 2 places. Number 1, we have statutes, employment standard statutes, legislation, that provides for certain minimum entitlements. But frankly, it's not that important because your full entitlements comes from what we call our common law. In other words, judges and courts over the past 150 years have established what people are owed if they lose their job. And that's ultimately what matters. That's why I can tell you that after 3 years of employment, you may be owed 6 months severance or more, because that's what our common law has established. So common law is a source of legal rights that every employee has, and when it comes to severance especially, it could be the most important source of rights.
5 common employment law terms. We'll wrap up with a big one here. This one's been huge, actually, over the last several years. As you know, Lior, that is temporary layoff. How does that work?
So the idea behind a temporary layoff is that the company is not necessarily letting you go, at least from their perspective. They're simply saying, we're going to suspend your employment for a while. We're going to put you off work on a temporary basis with the idea that we'll call you back in a few months or at some point down the road. A temporary layoff as opposed to a permanent layoff. Well, not so fast. Even though a company may often do that, my gosh, as John said, we've seen this so many times during the pandemic. Even though a company may say that they're doing that, may intend to do that, the law says not necessarily. In most cases, a temporary layoff, the law considers to be a termination, considers it to be a permanent layoff. Company does not have a right to put you on a temporary layoff. So if you've been put on a temporary layoff, you can accept it, sure you can, and you can sit at home and wait to see what happens. Or you can choose to consider it a termination and get your severance now. There's no right to do that, so a temporary layoff is in fact a termination in the eyes of the law.
Quickly though, what's the pitfall of accepting it and staying at home? Because it's already a 100% pay cut.
Yeah, so that's bad enough, right? Who wants a 100% pay cut? But it does get much worse than that. If you accept this temporary layoff, which again, you don't have to accept, the company doesn't have a right to impose it on you, by accepting it, you've given the company the right to do it again and again and again. So they may call you back to work, but because you accepted it the first time, they could put you on another one and another one and another one. So you may find yourself that you're not working more often than you are working. Why? Because you accepted that temporary layoff the first time.
We have got over 10 years of radio shows and great phone calls have come in over that decade. We're going to pull from another recent show and talk about it. Phone call number 2 from the radio show coming up right now.
I was recently terminated from my job. I was working with another coworker, and he had a problem with our boss. Our boss was making rude statements about another employee. My coworker complained to HR about in regards to what he was saying. He mentioned that I was a witness. HR reached out to me. I said, yes, I did witness what he did say. He did say all those nasty things about another coworker. Within a couple of days, I was terminated.
Yeah, that's wrong, but forget wrong, it's illegal. Right? You cannot be let go because you're standing up for your rights or someone else's rights when it comes to workplace harassment. You have a right to say what you know. You have a right to pursue fairness in the workplace. You have a right to try to eliminate workplace harassment. We all have a right to work in a harassment-free environment, and we can't be punished because what we're trying to do is stand up for our rights or someone else's. So this person, if in fact he was let go because he told the truth when it comes to harassment, that's what we call a reprisal. That's illegal. That could be a violation of employment standards. It could be a violation of occupational health and safety legislation. It could even potentially be a human rights violation, a wrongful dismissal, you name it. Now, if the decision to let him go had nothing to do with this harassment issue, well, maybe then it's just about severance. I don't buy that. If you talked about harassment, you said what you know, and then you were let go a few days later, something here is wrong. So I want everyone to understand that if you complain about harassment or you provide information, you're a witness to harassment, you're coming forward, you are actually protected. And an employer that does anything to you in that situation is going to have very significant consequences. It simply cannot happen.
And with that, we'll take one more short break. Loving the phone calls. We get to our third one on the other side. So in the meantime, we want to reach out to Lior, find a radio show near you, employmentlawyer.ca. You can also call and find out, 1-855-821-5900. This is the Employment Law Show. We're coming back with more.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back, Employment Law Show. A few minutes to go. Let's dig right in. As mentioned, employmentlawyer.ca. That is the source to find a radio station through our media page. In a market close to you, for sure, you can tune in every week, and the opportunity to call in is always there and ask your questions. We'll get to our third phone call now, Lior, from one of our radio shows. Let's do it.
Small tech company working for about 3 years. The employment changed from full-time hours. They asked to go into part-time. Didn't sign anything, but so I guess I've agreed by taking on the part-time hours. And then within about a month or two, was terminated without cause and offered 3-week severance.
So the first thing I'm going to talk about is the fact that he accepted the reduction from full-time to part-time. Certainly, he did not have to. An employer does not have the right to change you from full-time to part-time. That's a huge change, and that would result in what we call constructive dismissal. So he actually would have been better off, sometimes hindsight is 20/20, but he would have been better off to say, no, I'm not doing that. I'm treating this as a termination. Now you have to pay me my severance based on my full-time hours. Unfortunately, he accepted the part-time reduction. So now he's a part-time employee. He still gets severance, except it's going to be calculated based on his part-time earnings. But just because he's part-time doesn't mean he doesn't get severance. So we know this person was there for 3 years and he was offered 3 weeks. And some people may say, hey, it's a week per year. That sounds right. Wrong, false, not even close to being right. So we're going to go back to our pocketemploymentlawyer.ca tool. We're going to use our severance calculator so you can see how much he's owed, so you can see how much you are owed potentially in this situation. So let's see what that gives us. So we know that this person has been there for 3 years in a tech role. He was offered 3-week severance. You see on the screen there, he's owed 3 to 5 months severance. So the 3 wasn't that bad. It's the fact that it's months, not weeks.
Right.
So that's why, as a short service employee, even a part-time employee, yes, significant severance is still owed. So part-time employees, guess what? You guys still get severance.
So the boat sailed for this guy because he jumped right into it and kept working. Is there something he could have done? Could he have said to the employer, employer, not big on this, but I like working here. I got a lot of chums. Can I just take it out for a spin to see if it works for me? And if not, I'm not going to keep it.
So he could have absolutely treated the reduction as a constructive dismissal, but he could have said, well, listen, maybe I like it. Maybe I can manage with the income, so I'll try it for a bit. So if you're going to accept temporarily a change that your employer is implementing, what you need to do is send them an email or a text message, as long as it's in writing, saying, employer, you've implemented this change. I don't think I'm cool with it, but I'm going to try it for the next 2 or 3 weeks, and then I'm going to let you go what I think about it. What you do by sending that email is you've given yourself some time to try it out without that being held against you. So you have the ability to try it out for a little while, 2 or 3 weeks, not really any longer than that. And then you can still say constructive dismissal if you've decided that you're not okay with that change.
We got time for one more question from Lior's live stream at stlawyers.ca. You can catch that on LinkedIn and on Facebook as well. Says, I worked at a marketing agency for 2 years before I was let go with 2 weeks' pay. My boss told me that I had a poor work ethic and lacked attention to detail. However, he was aware that I was suffering from an ongoing mental illness and failed to offer any real support through that period. Is this a wrongful dismissal?
So it may not be a wrongful dismissal. What it could absolutely be is a human rights violation. You cannot be let go because you're suffering from a medical condition and it's impacting your work environment or your work performance. So what you have to do, if you're in fact suffering from a mental health issue or physical issue, you have to tell your employer about that and in fact give them a doctor's note. Tell them that your performance may be impacted, because then they have to accommodate you. They have to understand. They have to be reasonable and helpful. And if they don't, that's significant. And of course, even after 2 years of employment, even if you're working for an agency, you're going to be owed severance that's calculated in months. But remember that duty to accommodate.
At least accommodation would have to be made, like at least that much, right? They
Absolutely.
Take it seriously.
Your employer doesn't have the ability to say, well, we're going to turn a blind eye to it. We kind of know, but we're going to pretend we don't. If you have a limitation, a medical limitation that impacts your ability to do the job, tell your employer. I know it sounds counterintuitive to tell them, but once you tell them, they have to accept it. They have to accommodate you. You're empowering yourself, and of course, that doctor's note is very important.
Always the gatekeeper of your health is your doctor, and they have the final say whether you can work or not, really, right?
An incredibly powerful tool, that doctor's note. If you have that, now the obligation becomes that of your employer to accommodate. And if you have that, you are protected, and your employer has to comply with it.
And we are done for another show. Thank you so much for your contributions on the phones and the phone calls through the radio stations as well, and the radio program. You want to reach out. Now that we're done, 1-855-821-5900, employmentlawyer.ca, pocketemploymentlawyer.ca, and of course the email is simply help@employmentlawyer.ca as well. We'll catch you next time right here on the Employment Law Show. Thank you so much for tuning in. We'll catch you next time.